Welcome everybody, my name is Jeff Davis. I will be presenting to you Tinker versus Des Moines School District, U.S. Supreme Court decision 393 U.S. 503, decided on February 24th, 1969. Yep. So this all was happening in Iowa, obviously Des Moines, Iowa. Okay, so a little bit of background and facts. In 1965, Robert Kennedy called for a Christmas truce in the war of Vietnam. Okay, Des Moines activist parents Tinkers wanted to support the idea of activists, support the symbolic protests, and so they basically wanted to be in favor of what was going on with the proposed Christmas truce for the Vietnam War. Okay, so for their children, one of the children's friends, they all said that they wanted to wear black armbands in solidarity to the protest of the Vietnam War. All right. But unfortunately, a lot of protests in this time frame in American history was also coincided with violence. So the school board kind of were like, hey, have you heard what the Tinker kids? Apparently they plan to wear black armbands as protests. And then someone else is like, hey man, we can't be having that. All right, what's going to happen there? And then someone else was like, man, I don't think so. Yeah, no dice. And then so apparently they wanted to say, let's draft a policy and suspend them until they comply. So they were saying, hey, let's go ahead and make sure that we make them comply to the standards. If they don't comply to the standards, then we'll just suspend them until they agree to come back without the armbands. And so, like a little bit of humor there, blind compliance. Yes, that will show those hippies. Okay. But the problem with what the Tinker children were planning on doing, it was nothing more than a silent protest. They only wanted to wear these armbands. They didn't plan on picketing out in front and causing for violence or anything. They just wanted to wear some armbands. Okay? So, in that school system, one day, even though the school district was like, no, policy says you cannot wear any kind of armbands, Mary Beth Tinker and her brothers decided, hey, we're going to wear these armbands anyways. Okay, so basically stick it to the people. So whenever Mary Beth showed up to school, they were like, hey, you need to go down to the office. So she went down to the office, and even though she was going against the school policy, she got told, hey, you need to take that armband off. And so she's like, okay, yeah, you're right. So she took it off. But the school said, hey, you knew the policy, you knew what was going on, so they suspended her anyways, which was not good for the school district. Okay, so eventually the Iowa State Civil Liberties Union got together with the Tinker family, and they're like, hey, we want to bring suit against the school district. And then the American Civil Liberties Union, aka the ACLU, they decided that they were going to pair with them as well. So the Tinker family took it in front of the school board, and then they ended up filing with the state saying, hey, this went ahead and this violated the First Amendment protection of free speech, and then also violated the 14th Amendment due process clause. So they filed suit with the U.S. District Court, and then whenever they filed with the district court said, we're going to affirm with what the district they wanted to say what the school district said. So they ended up following it with the Supreme Court, the U.S. Court of Appeals of the 8th District for Iowa, which ended up in a tie with their vote, which deferred to the lower court. So they couldn't come to a decision. It deferred to the lower court. So the lower court's like, oh, man, you know what? It ends up going back to the original decision, which was ultimately just still saying, hey, you can't wear those. So what does that mean? That means that this went to the Supreme Court. Okay. ultimately, the issue is that the right to freedom of speech is constitutionally protected. However, it does not protect against the freedom of consequences. So yes, the students were protected in their speech, but punishment could come down from that, right? Students that protest, though silent on school grounds, could potentially disrupt the nature and intent of the purpose of schools to educate. Administration has a responsibility to establish a learning environment free from conflict as much as possible. So the question arises whether this decision infringed on students' rights to free speech on campus by wearing armbands, and whether or not it was unconstitutional. Okay, so the U.S. Supreme Court came to a 7-2 decision, and within that decision, Justice Abe Fortas came through and was like he was the majority decision author, and said it can hardly be argued that either students or teachers shed their constitutional rights of freedom of speech and expression at school gates. So basically saying, hey, just because you're going to a public school doesn't mean that the rights of the Constitution are thrown in the trash can. Okay. However, there was a dissenting opinion. Justice Hugo Black, he said that disruptive symbolic speech is not protected by the Constitution, and that they were unelected Supreme Court justices, and that they should stop acting as if they were this super school board when school systems cannot make compromise with their constituents. They ultimately, there was also a concurring opinion where Justice Warren believed silent protest was passive and protected by the free speech clause of the First Amendment of the Due Process Clause of the 14th Amendment. So ultimately, when it comes down to is whenever a student is going to protest, they must understand that a school district and an administration has a right to ensure that they are doing the one goal, and that's making sure that the environment is educational. So in the event that they are not allowed to protest, the district or the school must prove that it is materially and substantially interfered with the requirements of appropriate discipline in the operation of the school. All right, so a couple of key points. Freedom of speech is not freedom from consequence. Students, so this is going to go later on in the Bethel decision, where a student used a lot of sexual slang in a speech and ended up getting in a lot of trouble. All right, just because there's freedom of speech doesn't mean that you are free from judgment. And then this would later on set a precedence for free speech and the rights of students in schools from the 70s until modern day. Okay, and like I said, Bethel School District number 403 versus Frazier is going to be explored later on, but ultimately the types of speeches that students use within schools or their acts is not necessarily 100% guaranteed by the freedom of speech. So if they try and act out or do something wild, is it materially and substantially interfering with the requirements of appropriate discipline in the operation of schools? If it does interfere with the appropriate discipline of the operation of the school, then it's not protected within the Constitution. Okay, thank you for your time, and I hope you enjoy this